Brandy Johnson with JB Networking Systems LLC.
All right, and what services does JB Networking Systems LLC typically provide?
Property management.
All right, and you have been hired prior to today's session
Yes, sir.
for position 5, Princess Davis. Is that correct?
Yes, sir.
You filed a designation of agency with this court on or about November 17th of this year, so 1 week ago. Is that accurate?
Yes, sir.
All right.
Yes.
So tell me about your relationship to Miss Davis.
Miss Davis just hired me to manage the property. She now lives in Brazil and needed to go back home for work and wanted a property management company to take over the property for her. So she asked my company to step in to manage the property.
Okay, so do you receive a check from or funds payment of some sort from Miss Davis in exchange for managing this property?
Correct.
So Miss Davis is making a payment to you personally.
Where our fees come directly from the property once we market and list the property for rent.
Okay, the property was occupied at the time you were hired. Is that correct?
Correct. That's correct. So I deferred payment until we're able to get a tenant for the property.
But Miss Davis, let me ask this first. Are you dealing with Miss Davis or are you receiving payment from some sort of other corporate entity?
Now the fees will come directly from the property. So it will be an equivalent to coming from Ms. Davis.
So at this point, there have not been funds paid by Ms. Davis to you.
Correct.
And you are employed by, what was the full name of the business again? Forgive me.
JB Networking Systems.
Okay. And so to the extent you're able to answer this question, how many hours per week do you work for Ms. Davis?
I don't work any hours per week for Miss Davis. We are now managing the property that is owned by Miss Davis. There's a tenant currently in the property right now, as you know, that's Mr. Williams. And upon getting Mr. Williams, out of the property, we will market the property and put a new tenant in the property. And that's where payment for the company will come from, the rental of that property.
So you're doing this almost on consignment. I'm sure there's a better term for it, but you're anticipating that based on the property turning over at some point in the future.
That's correct, Your Honor.
Okay. Have you engaged in any discussions with Mr. Williams, who is the tenant in the property now?
No, I have not contacted Mr. Williams because he's represented by counsel. I did reach out to his attorney to see when he anticipated moving out of the property. And of course, I didn't get anywhere with that. They had no answer of when he was anticipating moving out of the property.
Okay. Is there a copy of the lease that's already been submitted into evidence?
Yes, Your Honor.
Okay. And do you know approximately when that was done?
The lease?
Yes.
Yeah, he signed the lease in July of 2025.
I'm sorry, when was it submitted into evidence so that I can pull that up?
Originally with the original filing from Ms. Davis.
It's also attached to a couple of my motions, Your Honor, if you want to take a look at it.
Thank you.
I'm sorry to interrupt, Ms. Johnson. I apologize.
No
At the end of my motion for sanctions, it's on there. I'm looking at it right now. Believe my motion to dismiss as well. It's attached. Yes, it is. So there's a couple places where you can grab it.
All right. And I see the original that was filed around October 15th.
Yeah,
and then this was
copy of the lease.
So I'm scrolling through. I know that you're okay, and then your motions were around 1023. Is that right?
Let me take a look at the stamp
Or
date.
at least scanned in.
Yes, Your Honor, that's correct. The 23rd of October. They were stamped by the court.
And so, Ms. Johnson, you said that you have engaged in communication with the attorney regarding when the property might be vacated. Is that
Right.
correct?
When would Mr. Williams vacate the property?
All right. Did you have any discussions with Attorney Baxter about whether there would be any kind of arbitration process?
He wasn't willing to talk to me, so no. And of course, Mr. Williams has not paid rent since he moved into the property, but we're not asking for monetary value at this time because of the violation of the lease. We're just asking for him to vacate the property because of the violation of the lease.
And Mr. Baxter, I know the original filing was dismissed based on there not having been steps taken to pursue arbitration. Do you know offhand if you could remind me where that is covered in the lease?
Yes, sir. It is, gosh, I should know this by heart now. I think it's paragraph 23, as I recall. My memory's generally pretty good. Let's see.
I'm pretty close to that. If you dispute resolution, subsection E, this is on page 5. I'm sorry, page 9 of
Yes,
the
it's
documents that were
23E.
submitted by Ms. Davis. Subsection E, dispute resolution. Should a dispute arise from this agreement, the parties agree to attempt an amicable resolution. If unresolved, disputes should be settled by binding arbitration with the governing law following the rules of a mutually agreed upon arbitration association. The prevailing party may recover reasonable attorney's fees. This agreement is covered by the governing law. So are you familiar with that provision, Ms. Johnson?
Yes. But the arbitration was for rent. Mr. Baxter presented for us to do, I guess for Ms. Davis, not myself, but for them to discuss the rent because there was initially it was supposed to be a dispute over rent. There's not a dispute over rent at this point, and I don't think it was when Ms. Davis was here. The whole purpose of requesting the eviction was because of the violation of the lease for illegal activity as well as smoking on the premises. And we do have police reports that was submitted in the exhibits.
I'm gonna jump in here. Mr. Baxter, are there, before we deal with the arbitration issue
Mhm.
and any other requests that you may have,
I would like to jump in here, Your Honor.
and Ms. Steele, Ms. Williams, we're going to be at least a few minutes. We're handling a motions issue. So if anybody has other matters they're able to handle, this would be certainly an opportunity to take that time. Mr. Baxter?
Yes, sir. First and foremost, Your Honor, Ms. Johnson doesn't even have standing to be here today. She is not an attorney. She is not an agent. The lease
Yeah.
has not been, I would like to ask her one question. Has the lease been reassigned to the property management company?
It has.
Okay. Has there been a change in ownership of the property?
We are the property management company.
Has Miss Davis sold the property?
No, she has not sold the property.
Okay, then that's an impermissible assignment, Your Honor. Under paragraph 25A of the lease, it says right here, the landlord is prohibited from assigning the agreement unless there's a change of property ownership. Ms. Johnson doesn't even have standing to be here today, Your Honor. She is not an attorney. She does not represent, she cannot represent Miss Davis. She is simply a layperson, and there is no basis for her to even be arguing this case, first and foremost. Secondly, you've already dismissed an identical dispossessory, if you remember my face back from about a month ago, and you told Miss Davis to stop filing these claims in court and wasting the court's time and to abide by the binding arbitration provision. She has not once reached out to me about arbitration. I have emailed her several times stating that Mr. Williams is trying to resolve this issue amicably. I have asked her for a ledger. She has provided me an incorrect ledger that contains additional fees that she's not allowed to charge. For example, dispossessory filing fees, legal shield fees for attorneys, certified mailing fees, all sorts of different impermissible fees. I have told her we are willing and ready to go to arbitration whenever she wants to do so. And I'm going to renew my request today for fees for sanctions against Ms. Davis for continuing to file these frivolous actions in violation of 915-14.
It's not frivolous actions. I think that, you know, that she did reach out to you. She CC'd me on it. She blind copied me on the correspondence to Attorney Baxter.
Ms. Johnson,
Again, Ms. Johnson doesn't have standing to be here.
He literally wants this man to just live rent free.
Ms.
He asked
Johnson,
you
I'm
what
gonna
your bar
be
number
I'm gonna
is.
be real frank here. You're pleading, you're filing your designation of agency came into this process at an unusual stage for a case that has an unusual history. Words have meaning, especially when they are in the law. And the evidence that is before this court suggests that the case was filed by Princess Davis.
Correct.
Is there any information that that is a trade name or business name or a corporate entity of sorts that has some sort of tax ID associated with
Princess
it?
or Princess Davis?
Yes. Or is that Princess Davis the human being?
Oh, that's a person. That's a human being, Your Honor.
Okay, a human being can't sign a piece of paper to have some other, forgive the term, I don't mean this with any disrespect, but I'm going to use the term random because I can't think of what else to say. A person
Layperson.
selected at their leisure to come to court and handle their business. That's not how the law works. That's why I went to law school for 3 years. I'm assuming Mr. Baxter, Mr. Steersman, Miss Williams, Mr. Breedlove, and the others that are in this room did the same. We served our time because passing the bar is not just a metaphorical term for the test that we take. It is what allows us to come to the front of the courtroom and advocate for the people that we represent. You do not have those rights. You have those rights as an agent of your full-time employer if your full-time employer is a party to the action. The case that we are here for today is Princess Davis versus the tenant, not your property management company versus the tenant. And so she cannot select you to represent her any more than she could select her mother, her brother, or her next door neighbor to do that, unless some of the people that are on that list have a bar card and good standing. And so you are not permitted to be here on their behalf today. And so two things are going to happen. I'm going to prepare an order reflecting my factual findings in that regard. And counsel, I'll hear from you on your motion for attorney's fees.
Yes, Your Honor. I think my motion speaks for itself. This is the second time that Miss Davis has chosen to file the same dispossessory action in this court, has wasted your time, has wasted Mr. Williams' time, and wasted her own time filing this. It's in direct contravention of your own dismissal order, telling her not to file these claims and telling her that she was being dismissed for failure to take any steps to comply with the binding arbitration clause in the lease, which again, she drafted and she signed. And Georgia law construes all ambiguities in contracts against the drafter. This is her responsibility and her fault. The reason we're here today is because she refuses to comply with the terms of the lease that she drafted and she signed. And so I'm again asking for fees. I have filed an affidavit with this court notifying the court of the fees that have been incurred by my client since the beginning of this unfortunate dispute. Again, I would like to say, and this is coming directly from my client, he is ready and willing to go to arbitration whenever Miss Davis would like to do so. He wants to get this resolved just as much as she does. And he is kind of at a loss for words as to why she continues to file and make up these frivolous claims that have absolutely no basis at all, in fact. These are unsubstantiated allegations, and it's my feeling, although this is a little bit biased, is that because she didn't get the result she wanted a month ago, now she's trying to make up some other reason. By hook or by crook, she wants him out of this property, and she's not willing to compromise or negotiate or go to arbitration.
All right. I won't comment on, we can decide if that was editorializing or advocacy. It was certainly a bit of both and well stated, but we'll have the following results for today. There will be an order prepared detailing the reasons that Ms. Johnson is unable to appear in the case styled as it presently is. The case will be dismissed for a lack of evidence showing that arbitration was pursued pursuant a lack of evidence showing that it was pursued as required under the terms of the lease that plaintiff provided the tenant to sign. And I will review the pleadings regarding attorney's fees, and I will make a ruling thereafter of what amount will be awarded based on this filing. The parties for this case will be placed in the waiting room, and that will conclude this business for today. Good luck to you both.
Are we being dismissed, Your Honor?
Yes, you are. Court has concluded as it relates to your matter for today.
Thank you, Your Honor.
I
Appreciate it.
expect that order will be prepared by the end of well, it's a short week. Yeah, still by close of business Wednesday, I hope to have it submitted and then processed, hopefully no later than the 1st.
Very good. Thank you, Your Honor.
Thank you.